Employment contracts. Okay, it's a big field of law. There's a lot of stuff here. We got to talk about the protection of the intellectual property that your company has hired this person to create. We need to talk about restrictive covenants if this person is at risk of leaving your company and working for a competitor or becoming a competitor themselves, right? Or stealing your customer list, for example, or your trade secrets, or your vendor list, or even other employees. Okay. We also should talk about misclassification issues. Are they appropriately classified as a 1099 independent contractor, or should they really be paid as like a W-2 with withholdings and all of that stuff? So let's hop right in because there's a lot of stuff here. The first one that we wanted to go over is the protection of your intellectual property. These days, there's a lot of content that is created, at a company, and it's not like it used to be because we have SEO, we have search engine optimization, we have the internet. You probably have some branding stuff, maybe some copyrightable material. I don't want to get into like all the different types of IP. But we have plenty of videos on it, difference between a trademark and a patent and a trade secret and a copyright. But if your staff is at all involved in the creation of intellectual property, and I'm talking anything, do they help you make a marketing video like this one? Do they help you to write blogs? Are they creating like a logo ever for a venture of yours? Are they having to do with the trade secrets that you have with the company? Are they seeing your customer lists if that's important, or your vendor lists? Your pricing models, the margin that the company makes on a given product or service. Are they seeing any of this stuff? Because if they are, it's important that you put them on a couple provisions that needs to be in an employment contract. One is called a work for hire provision. Those are legally active terms, work for hire, that just says, based on the U.S. Copyright Act, anything that they create while on the clock for your company becomes your company's intellectual property magically and right away. Okay, so that includes trademarks, trademarkable things, patents, patentable things, inventions, ideas, trade secrets, generation of customer lists, anything under the sun that's an intellectual property, intangible property piece, right? So you need to be able to own that. If you don't, that means that these people could take it. They have an argument that it's theirs and not your company's, even though they did it, while getting paid by you. So these provisions are not read into an employment contract. You got to put it there, or you will lose that battle. Okay, so work for hire, and also you need confidentiality provisions, kind of like an NDA, but it's a little different for an employee. All right, restrictive covenants. This is another thing. So you have a lot of different ones these days. You have a non-solicitation, which prevents them from soliciting your customers, soliciting your vendors if they're going to set up their own shop competing with you. You don't want them to be able to go to your vendors and say, hey, I'll pay you 10% more if you work with me instead of them, and then they can undercut you in the market. You want to give them non-disparagement clauses these days. Companies really suffer greatly from a single negative review, even from workers, that can really harm a company's reputation. If you have a non-disparagement clause, it restricts their ability to give these public negative reviews without sort of coming to you first and, good faith, fair dealing, like figuring it out, right? And of course, the big one is a non-compete. I would say not everybody needs a non-compete, but if they're higher up in your firm and they're dealing with customers often, and there's a threat like of them becoming competitors or helping out one of your competitors, God forbid you spend a big investment of time and money in training these experts in how your unique company works, behind the scenes, and then they take that knowledge from you, and maybe even your bought and paid for marketing list, right? I mean, marketing costs, they're through the roof, right? You don't want them to be able to take those customers and just undercut your prices by 10% and like Walmart you out, like it was in the 80s and 90s. You don't want them to be able to do that. That doesn't make any sense. I don't think that they would believe normally that they could do that, but it definitely happens. And you can't read into a contract those provisions. If you're going to restrict their ability to compete against you after they're employed by you, you got to put that into a contract when they sign, like when they start. You can backdate, or you can't always backdate, but you can give them like a bonus or something, to sign a new agreement if they've been with you for a while, or maybe you give them a bump in their pay or whatever. But you have to have that in the contract before that contract terminates and they leave your employ. Okay, you can't. No judge ever will read into a contract and add those provisions, even if you think it would be more fair, or people would presume that would be in there. Okay. So we talked about non-solicitation, non-competes, non-defamatory language like non-disparagement. Another thing is misclassification issues, okay? So this is a whole field of law, and it's a factor-based test. So if you don't get it right, the only ones that are really going to win are the lawyers, and the Department of Labor, I guess, or the IRS, the feds. But you need to figure this out, okay? It's very tempting to not only the employer, but also the employee to, take home their whole paycheck, not make any withholdings, and just pay them as a straight 1099 contractor. That makes sense if it's like me hiring a guy to paint my law firm, because it's totally different from the legal services that my company provides. It's on a case-by-case basis. He can turn down the job and I won't fire him for future work. He can say, no, I don't want to do that. He uses all of his own materials. He uses his own company and his own branding, stuff, right? I'm not giving him paintbrushes to do this. I might be paying for some of the paintbrushes that he uses, but I don't, it's up to him, right? So there's no question that that's a pure independent contractor relationship between this painter and my law firm. But if you're hiring out, a lawyer that's, giving the legal services that your company tends to give, right? Certainly the mine does. And you give them a laptop and you're like, here, use this equipment to do these legal services, and wear our branded t-shirts, the whole time or whatever, put a vehicle wrap on your car. You can see how the factors tend to cut the other way rather quickly. Certainly if they're working for you more than 30 hours a week, and if they were to say no to a job, you would have an issue with that. You would have some beef with them. You're probably misclassifying this person as a 1099. And all of the liability for that misclassification is on you as the business owner. And oftentimes, as far as FLSA rules go, you can't even bankrupt yourself out of it. We had a company a while back that got audited by the Department of Labor, and when they first hit them up, they said that they owed $250,000 to these ex-employees and the federal government for back taxes and underpayment of overtime and all of these other things, even though every single one of those workers wanted to be paid on a 1099 basis. So it doesn't matter that they ask for that, right? The Fed doesn't give a shit. You have to make the correct, legal determination and decision. So if you're at all on the fence about that, please give us a call. I'd be happy to, no charge, talk you through it. But that's a biggie. That's a big, expensive number that you can easily avoid, for very little. It's only, I think payroll tax is, less than 5%. So you're really not paying that much more for that insurance that you're not going to get smacked, with one of these audits. All right, so that's all the time we have for today. Feel free to reach out to us if you have any questions. I'd be happy to talk you through it, or anyone on our expert staff. I'm Jonathan Sparks with Sparks Law. Keep rocking, guys.